was knowing who I am. And when you're young and you're in your 20s, you're trying, I mean, at least I was, you're trying on personalities like they're shirts. I mean, you're literally just, I'll be this person, I'll be that person. And one day you've stolen from 1,000, so you're a genius, not a thief. And instead of stealing from one, and you've pulled all these different references in and these feelings, and you know yourself. And it's that, a lot of people, when they talk about things, they frame it like a TED Talk or something where it's like, I knew at the time.
The documents were leaked to the Daily Mail and Deadline, and the Daily Mail journalist, who's from the UK, said on Ask Two Lawyers that his source showed him a photo or image of the subpoena. But here's the thing, the lawsuit didn't list Stephanie Jones, and the only supposed defendants were Blake Lively's own employees. That raises a serious question. Why were Justin Baldoni and his records part of this case at all? That's exactly where the claims of bad faith, misuse of legal process, and general unethical behavior start to build. Wayfair and Belon have been making their stance clear through Brian Freriedman. As for what happens next, that's still unknown. There's been a lot of talk about Blake Lively, Ryan Reynolds, and Justin Baldoni after private records were sent to Stephanie Jones through what many believe is a fake lawsuit and subpoena. Hey friends, welcome back to my channel. People are now asking whether this is even legal and what the laws in New York say about subpoenas. Here's the thing, New York has very loose rules when it comes to this. A lawyer there can send out a subpoena without getting approval from a judge or a court clerk. That's because, under New York law, lawyers have the power to do this as long as there's an open case. However, a subpoena can be ruled invalid if it's shown that the case didn't matter, was filed in bad faith, asked for too much, wasn't handled properly, or didn't give enough notice. Wayfair has said they believe Lively hid her identity by using the Van Zandt Inc. lawsuit, which didn't actually sue anyone, so she wasn't required to inform anyone, and then gave the records to Stephanie Jones, and from there, Stephanie Jones. And employee of Geneable and a publicist for Wayfair, Stephanie Jones, gave private information to Blake about her former worker and old clients without telling them at all. Under New York law, you don't have to inform third parties if they're not directly named. So, for example, if Jen or Justin weren't subpoenaed, Stephanie wouldn't legally have to tell them. But if it's later found that a subpoena was used just to secretly collect info without alerting the people involved, that's considered acting in bad faith. Now, more details are coming out about why the subpoena was even used. Wayfair claims that on August 21st, Stephanie Jones gave private details to Blake Lively about Belon, Wayfair, and Jenel, the same day she fired Ale. Stephanie wasn't left out of any of this either. She was fully involved and Stephanie gave her thoughts on Melissa Nathan and suggested how she'd handle the crisis. She stepped in with the Daily Mail and even called Blake's claims of sexual harassment and feeling unsafe on set a nothing burger. But once Wayfair fired her, she suddenly called it a smear campaign meant to ruin Blake Lively. Either way, they had to deal with the situation, first, because Blake isn't allowed to get private information just because she wants it, and second, because Stephanie could have been sued by Jen, Belon, and Wayfair. So, how did the subpoena come out? Why was it shared? What started it all? The turning point was when Belon, Wayfair, and Abel filed counter lawsuits against Jones and claimed that the information was Jones gave the information to Leslie Sloan or Blake Lively's team without using a subpoena, and they kind of trapped her by pointing out that no subpoena had been issued. Right now, it's still unclear if the subpoena that was later used is even valid. That's something a judge will have to decide. But there's definitely a lot of shady behavior around how it was handled. There are many steps the other side can take, like we talked about yesterday, things like asking for sanctions, claiming abuse of process, filing for summary judgment to throw out the evidence, and even going after the lawyers for breaking ethical rules. And then there's the whole idea. The biggest red flag was that every time the subpoena came up, whether in the Daily Mail or Deadline, it never mentioned which lawsuit the subpoena was tied to. Now, the person who leaked it is still unknown, but we do know it got out the same day Miss Jones filed a motion to dismiss the counterclaims. She said she had a subpoena and was only sharing the information because the court ordered her to hand over the documents. Things were leaking little by little, and that's where questions started. When it comes to the idea of blocking justice, contempt of court, or possible criminal charges, even though I don't really see that happening, it can happen in rare cases. Most civil cases don't lead to criminal charges unless, during the lawsuit, something comes out in discovery that proves a crime happened. That's how it usually works. And if there was a crime, it wouldn't be Brian Freriedman who handles it. It would be a U.S. attorney or a prosecutor, depending on the state, like New York or California. But right now, the case is still civil, and criminal charges haven't been added. What stood out to me most was that they didn't mention a case number or where it came from. At first, articles came out saying, look, there's a subpoena, it's from a court, everything's fine. It felt like this was coming from someone close to Jones, especially since her lawyers also said things like, we followed the law, we had to do it, we complied, and so on. Then the Daily Mail looked deeper and said, actually it was issued through New York County courts, but there's no court stamp. In New York, by the way, a lawyer can issue a subpoena without a judge's sign-off. Still, the fact that it was done in New York County helped me find the Van Zaan Inc. lawsuit. That lawsuit didn't list any defendants, and Stephanie Jones wasn't. The issue is that Jones, who was Jen Abel's boss, was using Jen's phone. And if that phone had private details like her birth date, social security number, medical, or doctor info, or anything sensitive, no one was there to protect Jen's rights or stop that from being passed to Lively through the Van Zaan lawsuit. As her employer, Jones likely should have. The day before, Deadline revealed the subpoena targeted Jen Abel's phone, and one article said it was looking for electronic records, data, documents, and messages in her possession or control from December 1st, 2022, onward. The journalist from the Daily Mail, who's based in the UK, said on Ask Two Lawyers that while his source showed him the subpoena to prove it was real, he wasn't allowed to publish it, reveal where it came from, or name the source. He could see what the subpoena was asking for, but he was told not to share certain details about what documents and info were being targeted. Even though it's not technically illegal to disclose the subpoena, Jones could still be held responsible for not informing Jen, her former employee, that records were being targeted in a third-party subpoena. Jen would have asked, "Who's Van Zaan Inc. and what do they have to do with me?" and could have fought the subpoena. The journalist believed that whoever leaked it, someone they know the identity of, did it to stop the public narrative that there was no subpoena. What I still find strange, though, is why no one has provided a copy of the subpoena to the court. Why did the source care more about controlling the public narrative than about what was actually going to happen in court? If the subpoena had been filed in court and listed as an attachment, then, once a subpoena becomes part of the public record, anyone can access it. I believe the reason they didn't reveal it was because we'd all want to know who's Van Zaan Inc. and why they thought they had any right to Jen Abel, Balon, Wayfair, and Jamie Heath's records. Why was Stephanie Jones receiving a third-party request from Van Zaan Inc., a company with no connection to any of these people, about reputational damage to Blake Lively and Ryan Reynolds, except not directly to them, but to their company, Van Zaan Inc.? That's why it wasn't attached. Once it became public, it would have sparked a storm of questions. Why would they do this? It seems strange. And now, today, the attorneys are claiming that everything they did was normal, that everything is legal, and they're acting outraged because we uncovered their smear campaign. The problem is, we've seen most of the text messages, including the ones Lively has selectively used to back up her claim of a smear campaign. We've seen replies that don't support her story, ones where they're not taking credit, joking that they weren't involved, but Lively accuses them anyway, just like she's doing now. I also think this subpoena, issued the way it was, makes Blake, Ryan, Jones, and everyone suing Wayfair look like hypocrites because they've demanded the court hand over these highly confidential Blake Lively. Through Van Zaan Inc. and Stephanie Jones didn't seem to care about violating the confidential trade secrets of Wayfair Studios, Jen Abel, or Justin Baldoni. Despite claiming that Wayfair might use information to destroy their careers, they themselves disregarded privacy with this subpoena. They even argued that the information they had was so explosive and enticing that it could destroy the people involved if it fell into the wrong hands. Does anyone remember what Lively's attorneys said in court on March 6th? They argued that, unlike typical cases, the people involved on both sides are in businesses that thrive on providing information to the press and content creators. It's not meant as an insult, just a statement of fact. Their work relies on making money and staying in the public eye. Blake Lively's attorneys argued that the defendants have bragged in text messages about their ability to leak information in an untraceable way, without leaving fingerprints, and with individuals who would do anything for them, especially those who dislike Lively. They said they would pursue more evidence of this through discovery. So far, the evidence shows a significant risk in this case, unlike others before the court. What they were trying to claim was that Baldoni would take the information from discovery and leak it to the press in an untraceable way. Ironically, this sounds a lot like what Blake Lively did herself, using an untraceable lawsuit in New York with no fingerprints on it, relying on individuals willing to act for her. They argued that there's an insatiable appetite for any information about this case, no matter how scandalous, and that even the most routine details become tabloid material. They pointed to a recent story from the Daily Mail, which had insider information about the first group of potential witnesses in Baldoni's case. Their concern was that discovery information
But what
could
I
end
thought
up in
was
the wrong
weird
hands,
when all of this
causing
happened,
harm.
and I still
They
think
tried
is
to shift
weird
the blame to
today,
Wayfair,
is why
claiming
hasn't
they
a
were the
copy
ones
of the
leaking
subpoena then been
information,
provided
but
to the court?
ironically,
Why
it was a
did
subpoena
the source
undisclosed to Wayfair
care
that ended
about
up in
the
the media.
narrative
They accused
in
Wayfair
the
of leaking, but it was them doing it all along. This suggests that part of the reason they withheld the subpoena was because it didn't fit their narrative about Wayfair and, in fact, exposed their dirty tactics. To make matters worse, they also brought up concerns about third parties. What they did with Stephanie Jones was crucial. She was a third-party subpoena in the case, not listed as a defendant or plaintiff. They argued that third-party discovery could cause significant harm if irrelevant communications with high-profile individuals unrelated to the case fell into the wrong hands. They emphasized the need for attorneys' eyes-only protection, claiming the high PR value of the information could irreparably harm third parties. Yet, this is exactly what Blake and Stephanie did to third parties who were targeted in the subpoena, using the information for PR purposes, causing harm in the process. They wanted to protect their third parties but didn't care about exploiting people like Baloney. This hypocrisy suggests why the subpoena was leaked. It was to prevent it from becoming a big story, revealing the truth all at once. They argued that releasing information about third parties could harm their reputation and privacy, and that the government has a strong interest in stopping such abuse. She accused Wayfair of possibly exploiting her clients by leaking information to the tabloids, yet they did the same thing. Then, her attorneys raised a hypothetical situation. They said, let's say Mr. Baldoni has a very high-profile friend, and he was just venting about his day, mentioning something about our clients in connection with what happened on set. That could be relevant, but its value to the case would be overshadowed by who he was talking to. They were concerned about third parties having their privacy violated, yet they didn't consider Jen Abel's or Baloney's privacy. Despite being third parties in the New York case, their rights were ignored. After losing and having a subpoena thrown out, they continued making discovery difficult for the Baldonian team, who still hasn't received a copy of that subpoena. All of this feels like a game to control the story, accusing Wayfair of doing exactly what they had already done. Freriedman set a trap to force the disclosure of the subpoena and reveal its true nature. The subpoena was listed in a claim, which would require discovery and its eventual release. We know that so far, Lively's Marjorie's attempts to obtain phone records have been blocked, just like in the federal case. I doubt the court will look favorably on her actions in the New York case, especially after failing to notify anyone and misdirecting the judge to believe that Wayfair was the real threat. There's evidence from Balon's side, including the unedited video and a phone voice memo, but no legal records, subpoenas, or confidential documents have been released that could harm anyone. Instead, they've only released evidence that refutes the claims. The subpoena has become a major point in the lawsuit. Rather than presenting it to the court, they gave it to the Daily Mail, capitalizing on its PR value. They handed the subpoena to Deadline, completely disregarding the court's discovery orders. This subpoena was part of the discovery process, and typically, pieces of discovery are not disclosed publicly before being provided to the court. Instead, they've chosen to release this information before it's even been officially handled. And the worst part? It wasn't Wayfair doing it. Now, I've had a chance to connect with a few people close to Balon. I'm not going to reveal who or share everything that was said, but I want to make something clear. I've never reached out to anyone connected to him directly. I just wanted to check in and see how everyone was holding up. What I was told was heartbreaking. This has been a devastating experience. It's been unbearable, beyond comprehension, for his family, friends, and everyone close to him. His entire life, both personally and professionally, has been completely shattered. They had no idea about this lawsuit. When I asked, they were shocked. When they found out, they weren't surprised. They knew exactly what had been done to obtain those records. They were all too familiar with how dirty these people play. It's become the norm for them. It's disheartening, and it breaks their hearts. But at the same time, it's become so routine for them that it almost feels like just another day. Oh, this is what they did. Dealing with Blake, Ryan, and these people felt like walking on eggshells, like constantly avoiding landmines, never knowing what would happen next. It was that hostile, or at least that's how it was described to me. I also asked about the smear campaign and made a comment about how it seemed to be coming from Colleen. It all started with Colleen Hoover's fans, from her Facebook group. There was backlash about the wardrobe, the castings, and even about Colleen's book promotion, the It Ends With Us coloring book, which caused a huge uproar. I pointed out how Lively should have known this promotion wouldn't work, especially after seeing what happened to Colleen. But all they said was, no smear campaign happened. The backlash? It all came from Colleen Hoover's loyal fans, the book talk community, and the survivors who didn't like how things were handled. They downplayed domestic violence and didn't seem to care about the tone-deaf self-promotion. The fans found it all offensive, but they didn't have to do anything. They denied it all, saying sexual harassment never happened. It was just a game, with no clear goal. I made sure to let them know that people are thinking good thoughts, sending well wishes and praying for them. At the end of the day, everyone is fighting for the truth and for transparency. Everyone just wants justice for Justin, his staff, his wife, Jamie, Jamie's wife, and all the women involved, Jen, Melissa, and Jed Wallace. They really appreciate the support, as it's been a hopeless experience for them. At least in that way, we're doing a bit to help. They weren't feeding me any information for a smear campaign. They only confirmed what I already found online. There's no smear machine. What do you think about all this? Share your thoughts. In the comments below, give this video a thumbs up and don't forget to subscribe to my channel. Do you think Brian Friedman's trap is what revealed Subpoena Gate? Let me know in the comments. Thanks for watching. Bye.